Good afternoon, everyone. My name is Emily Sumner, and I am the immigration attorney, one of the two immigration attorneys right now at Sumner Immigration Law. We are talking today about the life after filing the I-45, what happens, what to expect, timelines, things like that. I want to first make sure that everyone can hear me. So if you can put in the chat really quickly that you can hear me, that would be helpful. Someone, anyone. I'm also going to mute everyone. Okay, great. Folks are telling me that they can hear me. So we will go ahead and get started. Thank you all for joining us today. An overview of the topics. First of all, this presentation is primarily about the life after filing the I-45, meaning the employment-based I-45. Lots and lots of clients filed those, the I-45, employment-based I-45 in October of 2020, or possibly before or after, but we had lots of people, we'll talk about the reason for it, that filed in October of 2020. And this webinar is primarily about that. I know that we have some participants who have filed a family-based I-45, so I'm going to cover a couple of topics in the first couple of slides that relate directly to the family-based I-45s and also are applicable to employment-based. But if you filed a family-based filing and you get the information you need in the first few slides, I'm not offended if you drop off, because the rest of the presentation is going to be, like I said, primarily about employment-based I-45s. Meaning if you had a employer sponsor you for the perm labor certification process and then filed a 9140. So just wanted to give you a heads up. But otherwise, we'll be talking about what is the I-45, estimated timelines for processing, travel, whether you can travel once you have filed the I-45, what to do about work. Do you work using the EAD, or do you maintain H-1B status or L status, whatever status you're on? What happens if you want to change employers? And there's a bonus tip at the very end. But otherwise, I hope that you will ask questions throughout. A lot of you submitted questions, which was really helpful when you registered, and I tried to address as many of those questions as I could in planning this presentation. If you submitted a question that was very fact specific, I'm not able to answer that in the course of a webinar in this forum. But if you have a very fact specific question that you'd like to send to us, if you're a current client, please do that. We're happy to help if we can. If you're not a current client, we would probably ask that you set a time for a consultation so that we can get all of the information that we need in order to properly advise you. And then finally, before we get started, as always, this webinar is for educational purposes only. The information that I'm giving is not legal advice. If you have questions about what to do in your specific case, please contact us or another qualified immigration attorney, hopefully us, and we're happy to advise you, but I can't give legal advice in this particular format. So what is the I-485? The I-485 application is the application that a person files when they're in the United States and they want to apply for permanent residence from within the United States. It is sometimes called the adjustment of status application because you're adjusting your status from some other classification, whether it's an H-1B or from ESTA or a B-1, B-2, some other classification, to the classification of permanent residence. When you file the I-485 application, and this applies to family-based filings as well as to employment-based filings in addition, when you file the I-485, you also apply for, or you can apply for, the travel document, that's called the advanced parole document, and the employment authorization document, which is called the work permit. A lot of times, especially in the employment-based context, someone will say that they've filed for the EAD. That's not a thing. You file for the EAD, of course, but that's always part of a larger application, whether it's an H-4 EAD or an EAD that you file in connection with the I-45. So I hear people say all the time, oh, I filed my EAD, and really what they mean is they have filed a 485 application to obtain permanent residence, meaning ultimately to obtain a green card in the United States. And the EAD is what's called an interim benefit. So eventually, we'll talk about timelines in a minute, but eventually you will receive the work permit in order to work in the United States until the time that you receive the green card. But the EAD itself is not the primary benefit, even though in a lot of people's minds it is. So in the employment-based world, in general, there are exceptions to this, but in the employment-based world, the process is that your employer would file a perm labor certification. Then once that's approved, they would file the I-140 petition, and then they would file the I-485. There are lots of steps that go into the perm labor certification and the I-140. This is not the webinar for that. We're not going to get into all of that today. We're only focused on what happens once you file the I-485. For anyone who filed a family-based I-485 and who is on this webinar and wants some information about what to expect for that, this is your slide. This is for you. This is your information. We have lots of questions about driver's licenses just in general. When a person applies for the I-485, when can you apply for a driver's license? So that varies by state. In Virginia, the law is that a person can apply for a driver's license once they have the I-485 receipt notice. So the receipt notice, and we'll talk about other specific timelines in a minute that apply to all 485s, but the receipt notice you get usually within about a month to 6 weeks after filing the I-485. It can take longer. We'll talk about that in a minute. But once you have the I-485 receipt notice, you can apply for the driver's license. Again, this is state specific. So if you're not in Virginia, you have to look up the requirements, or we can help you. If you're a current client and you have questions, definitely let us know, and we're happy to help you out. But in Virginia, you have to have that I-485 receipt notice. In addition, in Virginia, you have to show that you're domiciled in Virginia, that you live in Virginia. So there's a list on the DMV website, the Virginia DMV Department of Motor Vehicle website, that lists the types of documents, and I think you have to have 2 types of documents that show that you live in Virginia, that you're domiciled in Virginia. And that's because they don't want people coming from a different state, from Maryland or any other state, to apply for a driver's license. You have to show that you live in Virginia. That's separate and apart from your immigration status. So in terms of your immigration status, you have to show that you have the receipt notice and that you have applied for a green card. There are other ways as well. So if you're a person who has not filed for the 485, and you're here, let's say on an employment-based non-immigrant visa, temporary visa, there are other ways to apply for a driver's license. But I'm talking specifically about the situation of you have filed, let's say, a marriage-based green card, for example, then you need the receipt notice and then documentation to show that you are residing in Virginia. And again, that specific information is on the Virginia DMV website, and we're happy to answer questions for any clients that have questions about that. They don't list this on the website, but clients have said it's very helpful if you can take a certified copy of your marriage certificate and a photo copy of the marriage certificate when you go to apply for the driver's license. Social Security number is another common question that we get from people. For marriage-based cases or family-based cases, you have to have the employment authorization document approved. When we file the package of forms, as you may remember, if you've been through this process, there are lots and lots of forms that we have to file. When we file the I-765 for a client, most of the time, unless the client tells us otherwise, we will mark that the client would like to receive the Social Security number automatically from the Social Security Administration. So in the perfect world, once you receive the employment authorization document, you will also receive the Social Security number in the mail from the Social Security Administration. You won't have to go in, and that's great. We are finding that, especially recently, that's not happening automatically. So if you are in the situation where you have the employment authorization document, the EAD, approved, that's the I-765 approved, and you have not received the Social Security number yet, if you are one of our clients, let us know, and we're happy to help you walk through a solution for that. The process is a little bit different right now because of COVID. The Social Security Administration is doing things a little bit differently. But just know that there are solutions for that, and we're happy to help you walk through that. Finally, processing times is one of the questions that we have received a lot, understandably, from all clients. We'll talk about employment-based processing times in a minute. but from everybody who has filed a green card, and honestly, it's all over the place. Still for family-based processing, let's say for a marriage-based case, or if you have sponsored your parent and your parent if you're a US citizen, you sponsored your parents in the United States. I'm not talking about consular processing. So if you have family members overseas, that's a totally different process. But just in general, if you have filed the I-45 here for a family-based case, in general, it's taking about 9 to 12 months from the time you file to the time that you get the green card. There are always exceptions. Sometimes it is possible to have it approved sooner. Sometimes it takes later, but that's the general estimated time frame that we're seeing right now in real life, in real time, on the ground, so to speak. That's not just USCIS's time, which is not always so accurate. We have a relevant question here. Is it practical to get a social security number before the EAD approval? It's not possible to get the social security number before the EAD approval. The Social Security Administration requires that a person have the EAD approval. And again, that's the employment authorization document in order to get the social security number. So that's a step that has to happen first. If you have a situation where you need a tax ID number, let's say you need to file taxes, you're married filing jointly, for example, then it's possible to get what's called an I-10, individual tax identification number. That is something that's kind of out of our purview. Typically the CPA or tax preparer will help a person. And it's also possible to obtain that directly from the IRS, but that's what you would get instead of a social security number if you don't have the employment authorization document approved yet. So that's all I have for the family-based cases or family-based I-45s. Again, those were the main questions. If you have other family-based and other questions relating to the I-45 based on marriage or a family-based filing, let me know, send me a message here in the chat and I'm happy to address it if I can. Otherwise, if you're a current client, send us an email and we're happy to help. It's an I-10. I'm going to message this individual tax identification number. So that's the abbreviation, is the letters ITIN. All right, so we're going to move on to employment-based I-45s now. But like I said, anyone who has questions, keep putting them in the chat and I'm happy to help. So let's start with the visa bulletin. If you are a family-based filer, that is, if you were married to a United States citizen, or you are married to a United States citizen or permanent resident, or your U.S. citizen spouse or parent filed for you, then the things I'm going to talk about for the rest of the presentation probably will not make sense to you. Don't worry about that. It's not relevant to family-based filings. So if you hear me talking about the visa bulletin and all these other things, don't worry about the fact that you have no idea what I'm talking about. It's totally fine. For the I-45 applications, employment-based applications, it is not possible, as you probably know, if you know anything about this process, it's not possible to just file the I-45 right away, right? You go through the perm labor certification process, then you file the I-140 petition, and then you have to see if a visa, and when I say visa here, I mean an employment-based green card, whether a green card is immediately available or not. And the place that we get that, the source for that, is the visa bulletin, which is published once a month by the Department of State. It's available online. If you just Google May 2021 visa bulletin, it will come up. Make sure you're looking at the Department of State website. It'll say state.gov. So make sure you're looking at that and not something else that may not be accurate. I have posted on this slide the dates for filing visa bulletin, part of it, for May of 2021. This particular visa bulletin, again, is for May 2021. It's dates for filing. So there are two tables always on the visa bulletin chart. One is dates for filing, the other one is final action dates. I'm not going to get into right now why we have these two separate tables, except to say that we do. And we have to pay attention to, in order to determine if a green card is immediately available and if you can file, you have to determine which particular table to look at. So I'm going to switch for just a minute. This again is the final action date. The next slide is the dates for filing. and I should have labeled these. But you have to look and determine which one. The way that you determine which one is by looking at the USCIS website. So let's say that the May visa bulletin comes out and your priority date is current per the dates for filing table, which would be this one right here. So let's say that you were born in India and the priority date is May 15th, 2011. Your priority date is before that, and you think, great, I can file my I-45 now. I've been waiting for like 15 years, which is probably true. Then that doesn't necessarily mean that you can file. Instead, you have to look at the USCIS website, and they will tell you which date to use. This is very, very confusing. When all of this came out, in October, rather, the end of September of 2020, when it became evident that there were a lot of dates that were available, in other words, a lot of green cards would become available in October of 2020, the USCIS first said that we have to use the final action date table for employment-based filings, and then literally a few hours later, they said, no, you can use the dates for filing. So it's very confusing. There are some immigration attorneys, unfortunately, that I have talked to who don't quite grasp this concept. So it's confusing. If you don't quite get it, it's fine. That's why you have us to help you understand it. But to back up for a minute, this is the visa bulletin, again, for May 2021 final dates. There is a limit of 140,000 employment-based visas available every year. That includes spouses and children. So as you can imagine, they get used up like that. They get used very quickly. Because we have so many people who would like a green card in the United States, thankfully, we want you all here. There is a virtual line of people who are waiting for a green card. Your place in line is determined by a few things. One is your country of birth. You see these categories at the top, China, India, Mexico, Philippines, some Central American countries, and then all chargeability areas except those listed. Those are listed out separately. These countries are listed out separately because no country, this is in the statute, so in the law, no country can take more than 7% of the overall allocation of employment-based green cards. So if there wasn't a separate limit for these particular countries, China, India, Mexico, Philippines, and certain Central American countries, they would take more than 7%. So they have their own cutoff categories. It's important to note that this goes by country of birth, not by country of citizenship. So if you were born in China, but you're a citizen of Canada, that's great that you're a citizen of Canada. You may be eligible for a TN or other options, but you still, for the green card purpose, are still born in China, and you have to look at this column for China. So your place in line depends on your country of birth. It depends on the employment-based category, EB1, EB2, EB3, and this other workers falls into EB3 as well. And it also depends on your priority date. Your priority date is the date that the labor certification is filed. So the PERM labor certification filing date is important. If your priority date, let's say that you filed your labor certification on August, so let's say that you filed your labor certification July 31st of 2010, you look at this visa bulletin chart for May, right? And the priority date is August 1st of 2010, then you can file because your priority date is before this date. You can file the I-45. Again, you have to double check the USCIS website to see which one of these particular tables they're going to use. So again, this is final action dates. This is dates for filing. The idea behind dates for filing is that based on data the Department of State and USCIS have, they anticipate that these particular dates are going to become current soon. Again, that's based on the number of green cards that have been filed, the number of green cards that are being used currently. So the idea is that you should be able to pre-file, essentially, to file now so that USCIS can pre-work the case and have it ready to approve once the priority date is actually current. USCIS doesn't always allow us to do that. As I said, you always have to check the dates for filing or the chart to the USCIS website to see which one they will allow you to file. Again, if you're not quite clear on this, don't worry about it. That's why immigration attorneys have jobs. If you have questions, let us know, send us a question, send us an email, and we're happy to help. But I say that because I anticipate we'll talk about what to expect towards the end of this presentation, what to expect in terms of dates moving forward. But I say that because I do anticipate dates will move forward towards the end of this fiscal year and the beginning of the next fiscal year. And that will be important to know. Just because your date is current on one chart does not mean that you for sure can file. You have to double check to see what USCIS will accept. So post-filing timelines. I think a lot of the people who are participating in this webinar, who joined this webinar, have already filed the I-485. So what can you expect? I have put the general steps here on this chart, the anticipated timeframe, which is what we would tell people to expect ordinarily, and then what we're really seeing in real life, because it's different, as you might already know. So first, after we file the I-485, we receive the receipt notice, and we usually receive that within about 2 to 4 weeks after filing. When I say usually, I mean in pre-COVID times and pre-2017 or 16 times, let's say. So it's not always the case recently. Recently, for employment-based filings, it really has taken 2 to 6+ months to receive a receipt notice. When we filed all of the cases in October, for some of the cases that we filed earlier in the month, like let's say the first week of October, we received the receipt notices fairly quickly, within a month or so. But others, we were receiving receipt notices well into December, even January, February. So it is definitely taking a long time. USCIS says that that is because of the volume in filing, the increase in filings. A lot of people were able to file in October and November of 2020. And then also because of the COVID, they have reduced staffing, they say. Similarly, for biometrics appointments, biometrics is the fingerprinting. And remember, the fingerprinting has to be completed before you receive the I-485, before you receive the work permit and the travel document. Typically, we would tell people, you know, in quote unquote normal times, that you would receive the fingerprinting appointment notice about 6 weeks after filing. We have many cases, many I-485 cases where we are still waiting for biometrics, meaning cases that we filed in October, it's well over 6 months now, and people are still waiting for biometrics appointment notices. So that is not at all unusual. USCIS has said that they are thousands of appointments behind, again, because of COVID and because of the high volume. They have said they're trying, and we're seeing this to be true, that they're trying to reuse biometrics if a person has already had them completed, so that's good. And they typically will send us an email to let us know if that's the case. But just know that if you are still waiting for your biometrics appointment, that is totally normal. It's not unusual at all, as frustrating as I know it is. The next step would be to receive your EAD and AP. So that means your work permit, your employment authorization document, and your travel document. Typically, we would see those being approved within about 6 to 9 months after filing in normal times. We are seeing some that are approved now for cases that were filed in October, but certainly not anywhere near all of them, or even probably the majority of them. So those are still pending. It's to be determined how long that will take. But again, it's the volume of filing is what USCIS is telling us that's causing the delay. USCIS interview. It was required during the Trump administration. USCIS started, or under the Trump administration, they started requiring an interview for all or almost all employment-based filings, which was a change from previously. Previously, there was only an interview for employment-based filings if there was some sort of issue, let's say a criminal issue or a previous immigration violation, something that they needed to interview the person about, then there would be an interview, but otherwise it was waived almost all the time. That flipped, and under the Trump administration, they started implementing them. Now they actually are waiving them more and more. I don't think they've officially changed the policy, but they are waiving them very frequently. And most of the time now, clients are receiving green cards, employment-based, without the interview. So that's great that eliminates a step, and hopefully people can get their green card faster. The green card approval, typically if a priority date is current in normal times, we would say within 12 to 18 months. Now, who knows? Because we have all of this backlog, between COVID and the number of filings and these delays that we're seeing with biometrics and with the processing of the case. The other thing to consider is that we don't know exactly when the priority date is going to become current. So if you filed in October of 2020, because the priority date, you were able to file under the dates for filing, meaning your priority date was not actually current, but it was likely to be current soon, then you have to wait until that priority date is current per the final action date. So in other words, it's not enough just to be current under the dates for filing. You have to wait until it's actually current. And that may be soon, or it may be years and years. It just depends on the number of green cards that are used. So know that even though you filed, it does not necessarily mean that you're going to have an approval within a year or so. And I wish I could give you better timelines, but this is reality. So traveling after filing the I-485. One thing that you absolutely have to look at, and this is something that we as your immigration attorney can help advise on, is what is your current immigration status and is it dual intent? There are some statuses, or I don't know if stati is the right word, but anyway, there are some statuses that will allow, that are dual intent, namely H-1B and L-1. That means that if you hold H-1B or L-1 status, you are permitted to keep extending that status and to travel outside of the United States and return on your H or L visa without interrupting your green card application. It would not have a negative impact or any impact on your green card application. That's not true for other statuses. So for example, we have clients on TN, which is for citizens of Canada and Mexico. We have clients on the E visa, all different types of visas. They are not dual intent. Somebody has just asked about the O1 visa. That's quasi dual intent. I would definitely check with your immigration attorney before you travel to make sure you have a clean strategy for that. But make sure that you are, if you do decide to travel, make sure that you have a plan in place. Make sure that you confirm whether it's dual intent and will allow you to come back in without interrupting the green card process, or whether that will create a huge problem. Because if you travel on a visa that's not dual intent, not only are you not going to become able to come back into the United States on that, let's say TN, for example, the TN status, because it's not dual intent, but you've also abandoned your green card. Unless you have, this brings us to the next point, unless you have the I-131 approval. So that's the advanced parole. The I-131 is the name of the form that is used for advanced parole. So if you have the I-131 petition or application rather approved, if you have the advanced parole approved, then you probably can travel. Okay. Again, always check with your immigration attorney before you travel. We love to know when you're traveling just so that we can help advise of any changes that might have come up. But in general, if your advanced parole is approved, then yes, you can travel. Again, make sure that you coordinate with your immigration attorney. If the I-131 application is still pending, it will be deemed abandoned and denied. So we have had clients, for example, who travel on an H-1B visa and return to the United States on the H-1B while the I-131 is pending, and that's fine. They enter on the H-1B, they resume working on the H-1B, the green card application is not negatively affected, but the I-131 is denied because the person left the US while it's pending. And that's in the I-131 instructions. It's correct. It's not an error from the USCIS. So just know if you leave while the I-131 is pending, even if you have confirmed you have another way to get back in that will not affect your green card, then you can still have the travel document denied, which is a bit of a pain. Then you have to reapply when you get back. There's the consideration if you're on a dual intent visa such as H-1B or L-1, there is the option of returning on an H-1B or L versus using your advanced parole to re-enter. That's a strategic decision. Again, you should talk to your immigration attorney before you travel, before you leave the United States, and come up with a strategy for which one to use before you re-enter. There are a lot of times when it doesn't really matter. You could use either one. So it may be that you use your AP to re-enter. There's a memo that says you can actually resume working in H or L status and then file extensions subsequently, even if you have entered the United States on advanced parole. But again, every situation is different and there's so many different facts that can affect this. So make sure you confirm with your immigration lawyer before you travel. And then of course, COVID concerns, regardless of how you are re-entering the United States. Let's say you've confirmed you can re-enter on your H-1B or you have a valid advanced parole document. make sure that you're aware of travel restrictions in the country that you're going to and coming back to the United States. There are a lot of travel restrictions right now in place for a number of different countries, including still the European areas, South Africa, Brazil, and now India as well. So make sure that you confirm that as well. Working after the I-45 is filed. So there's always the question, and again, I can't give advice here, but these are questions that you should consider, and again, talk to your immigration attorney about. But there's always the question of whether you should maintain status, meaning should you keep your underlying non-immigrant status, so whether that's the H or the L or an E or TN, whatever it is that you're working on, versus just abandoning that and you working using the employment authorization document. There are pros and cons of both of them. In general, if I advise clients in general, and again, this is not legal advice specific to you, but just in general, I advise a person to maintain their underlying status, meaning their H or their L or whatever it is that they're working on until the green card is approved. Because if, God forbid, the green card is denied, then you have that status to fall back on, the H or the L or whatever it is that you're working on. It's not anticipated. You know, if I ever see a situation where I think this green card could be denied, I let clients know as soon as I recognize the issue, as soon as I see the issue, because I don't want surprises. I don't want my clients to have surprises. But there's some times where we can't predict that. USCIS makes an error, an erroneous decision, and a green card is denied. And if that happens, then you want to have that status to fall back on. There are other times where it just doesn't make sense. So definitely it's something that is very individual, and you have to talk to your immigration attorney to come up with a strategy for it. But it is nice to have that underlying status to fall back on until the green card is approved, if that's a possibility. If you work using the employment-based green card EAD, so in other words, the EAD that you received through the employment-based I-45 filing, then my take on that is you're no longer maintaining your underlying status, your H-1B or your L or whatever your underlying status is. So some people say, well, can I've heard this question before, can I work on H-1B, maintain H-1B, and then take a side job using my EAD? My answer to that is no. It's either one or the other. You can either work using the EAD, so you would work both jobs, you know, your kind of main job and then the side job using the EAD, or work just for your H-1B employer using the H-1B. Again, very fact specific. But know that it is not just, you know, have free reign, that, you know, just because you have the EAD does not mean that you have free reign to just go use that EAD to work for whoever you want to, in addition to the H-1B. That can cause problems. I've also received a lot of questions about, I'm calling it mixed status couples, but people will say, hey, I'm on H-1B, and my husband is on H-4 or vice versa, you know, whoever the spouse is. Can my spouse work using the EAD that he obtained through the employment-based green card process, and I will maintain H-1B status? The answer to that is yes. You can have a mixed status situation, a mixed status household, so to speak. So one spouse can be on H-1B, the other spouse can be on the EAD that they obtained through the employment-based green card process, whether they were the primary applicant or the derivative applicant. Likewise, if you are maintaining, let's say you're maintaining H-1B status, you and your spouse have filed the employment-based I-45, so you have the EAD, or you will have the EAD through the employment-based process. I get the question a lot, can my spouse still apply for the H-4 EAD? And the answer to that is yes. If you qualify, if the spouse qualifies for the H-4 EAD, then absolutely, they could work using that as well and maintain the H-4 status. So again, this is general information, not specific to anyone. I'm not saying you should or should not do, you know, any particular thing, but these are things that you should be thinking about and questions that you should be asking your immigration attorney to make sure that you have a clean strategy in place that will not cause problems later. Changing employers. So when I file an I-45 application for an employment-based I-45 application, I'm representing the employee and the employer. So I consider that dual representation. So a lot of times the client will come, employee will come to me and say, hey, I want to change employers. Can I do this? And I will tell you, I can't advise you because I represent both of you. This is general information that is available everywhere. So this is the information that I am able to give you. If you have submitted the I-485 application, if the I-140 petition is approved, and this isn't a requirement, it's not technically required in the regulations if to change employers while the I-485 is pending, and this is called I-485 portability, meaning this is a situation in which you can change employers without having to start the green card process over again. If the I-140 petition is still pending, that is, it hasn't been denied, it hasn't been withdrawn, anything like that, and if you were moving, we'll go back and talk about the I-140 being approved in a minute because I have something to say about that. If you are moving to the same or similar employment, and if the I-45 has been pending 180 days or longer, then you can change employers without having to start the process over again. There's a form called the I-485J that you probably submitted when you submitted the I-45, unless you filed it together with the I-140, which you may have. But anyway, there's a form called the I-485J. A lot of times before the I-485 is approved, the USCIS will send and I'm getting some questions on self-petitioning. We'll answer those in a minute. But before the I-45 is approved, USCIS will issue a request for evidence asking you to send in the I-45J. The I-45J is the form where either the employer who sponsored you in the first place for the perm and the I-140, they confirm, and you confirm on the I-45J that you're still working for that employer, or it's your opportunity to tell USCIS, no, I've moved to a different employer, I've ported, my I-140 petition is approved or is approvable, and we'll talk about that in a minute. Like I said, I have the same or similar employment. So you can't just change, from being an engineer to being an interior designer, for example. It has to be same or similar employment. And the I-45 has to be pending 180 days or longer. Going back to this point about the I-140 petition being approved, it's not required in the regulations that the I-140 petition be approved. However, I do not recommend that you port. I think it's dangerous to port before the I-140 is approved, because if it's denied, you're out of luck. And if you're porting, you're probably not maintaining. You could be maintaining the underlying status, but you may not be. So I think it's dangerous to port before the I-140 is approved. I think it's much safer to port once that I-140 petition is approved. Again, it's not required, but that's my general recommendation. Again, every situation is different. I know I keep saying that, but that's not legal advice. That's just a general consideration. Questions about self-petitioning. I think we have a couple of people who filed either an EB1 petition, so EB1A for aliens of extraordinary ability, or a national interest application, a national interest waiver application. Those are self-petitioning, so meaning you don't have to have an employer sponsor you. So no, the portability requirements are not quite the same. I do in general, and again, this is not legal advice, but just in general, I do recommend that you still maintain the same or similar type of employment. But because it's not tied to a specific employer, if it's not tied to a specific employer, then you don't have these same portability requirements. And then we've talked about this before, maintaining the non-immigrant status versus using an EAD. That's something to consider when you if or when you change employers. You want to think about whether you still want to maintain that H-1B status, or the L would be harder to maintain, but whether you want to maintain the underlying non-immigrant status or just work using the EAD. There's no right or wrong answer, but as I said, if you give up that temporary status, the H-1B, then you don't have that to fall back on if, God forbid, something happens with the green card application. But it is possible to port and also do, for example, an H-1B transfer. I've had people do that frequently. I had a question above about aging out a daughter's date of birth on H-4. I'm not able to answer that in this particular forum. If that's something that you have questions about, then feel free to set a time for a consultation with us, and we're happy to help. It's very complicated. There's something called the Child Status Protection Act, and there's a lot of analysis and calculations that goes into that. So know that it's important that if your child turns 21 before the green card is approved, that they don't automatically age out just because they've turned 21, but there are certain regulations and, like I said, calculations that can be done to see if they may still be protected under the Child Status Protection Act. So what's coming next? What can we expect? There is every month a chat with Charlie on YouTube. It is on YouTube. It's published by Department of State. So if you just Google YouTube Charlie Oppenheim, and I'm going to put his name here. Charlie Oppenheim is the name of the individual in the Department of State who is in charge of the visa bulletin. He's the man behind the curtain, is what I like to call him. So he gathers information from USCIS, data from USCIS and from Department of State each month, and then creates the visa bulletin. Basically, he, in other words, he changes the dates based on the data that he receives, and I'm sure he does some statistical analysis and sets the visa bulletin each month. So he gives analysis as to what's happening, some insight as to what's happening. That he used to have these chats with Charlie on a monthly basis through AILA, the American Immigration Lawyers Association, but they have since made them public, which is great because now anybody and everybody has access, and it's right there on YouTube. So you can get that, like I said, if you just Google Charlie Oppenheim and YouTube and visa bulletin, the link will come up. That's great information, and I'm glad that they are making that publicly available, and that's basically where I have received this information as well. So as you know, if you have watched the visa bulletin, dates are progressing. Charlie anticipates that the dates will continue to progress. The fiscal year for Department of State and USCIS starts on October 1st every year. So in the calendar third quarter, so starting in July, that's when we'll start basically the fourth quarter of the fiscal year. That'll be the end of the year. So he says that he's trying to encourage USCIS to pre-work cases so that they're ready to approve, and to really work the EB1 cases, which are, if you remember on the visa bulletin, it's that very top line, for aliens of extraordinary ability, outstanding researchers and professors, and certain multinational executives and managers. So he's telling USCIS, or encouraging them to work those cases so that unused numbers from those categories, from the EB1 category, will flow down to the EB2 category. And so we may see movement in the EB2 category, and then ultimately the EB3 category in the summer of this year, summer of 2021. We're not sure at this point what's going to happen in October of 2021. There is some speculation, unofficial, that we'll see some significant movement in the priority dates in October of 2021 because, and this is what happened last year. So like I said, the fiscal year starts in October. Last year in October of 2020, a bunch of numbers were unused. Numbers meaning visas, green cards, were unused because they otherwise would have been used at the US consulates. The US consulates, as you may know, unfortunately, have been closed or working at very reduced capacity since March of 2020 because of COVID. And that's still the case. That's been the case all through 2020 and through 2021 so far. Consulates are reopening, but it's not anything that's happening on a very expedited basis, unfortunately, at this point. So my point is, we anticipate that there will be a lot of unused numbers that will probably flow down into EB2 and EB3 as well. Again, we'll have to see whether USCIS allows us to use the dates for filing or final action dates. So if you see your date is current, check with your immigration attorney before you uncork the champagne thinking that you can file the I-485 or that you'll get the green card soon. Remember, for it to be approved, for your green card to be approved, it has to be current per the final action, not dates for filing. And then finally, you have to have, this is for anyone who has not filed the I-485 yet, you have to have an approved PERM labor certification and I-140 petition to file the I-485. So we had several people last year when the whole visa bulletin opened up in October of 2020. We had several people who said, oh, I have my I-140 petition approved through employer A that I worked with 10 years ago. So can I file the I-485 now? And the answer to that is yes, if you intend to return to employer A. But if you don't, if you have no intention of returning to employer A, then you have to have a perm labor certification that is approved through the employer that you're going to work for. Okay, so it's not enough to just have an approved I-140 petition from 10, 12, 15 years ago from some employer that you don't have contact with and have no intention of ever working for. So make sure, if you haven't filed the I-45 yet, make sure that you have a plan in place so that when your priority date is current, you're able to file the I-45. And then finally, I know we have a couple of questions here that I will check on in just a minute. But finally, your bonus tip is that you cannot keep extending the H-1B indefinitely. So if you are in H-1B status, and a lot of people who apply for the employment-based green card are in H-1B status. If you are in H-1B status, as you probably know, there's a limit of 6 years in H-1B status. You can extend the H-1B status beyond the 6-year limit if you have an I-140 petition that's been approved. And if that's the case, you can file in 3-year increments, but that's only true if your priority date is not current, if you're not able to file an I-45 yet, okay? So if you are able to file the I-45, that's no longer an option. The other option is if you have filed the labor certification or I-140 petition within 365 days before the end of the 6th year. I know this is complicated, but bottom line is you can just know that you can't keep extending indefinitely beyond the 6th year. But anyway, the other exception is if you have filed at least a year before the end of the 6th year, you can extend in 1-year increments. But know that in order to do that, in order to keep extending beyond the 6th year in 1-year increments, you have to file the I-45 application within a year of the priority date becoming current per the final action date of the visa bulletin. And then that clock resets if the priority date retrogresses. This is level like 301 of at least, if not more, of immigration law. It's complicated. And it's a rule that is not talked a lot about and that a lot of people may not know about, but there are people who could possibly be in this situation, so I wanted to bring it up. Just know that if you are past the end of the 6th year or approaching the end of the 6th year, if you have a really old I-140 petition, and you've just been using that to extend beyond the 6th year, know that that option might go away if your priority date becomes current. So the 3-year option would go away. And then the 1-year option, 1-year extension option would go away also if your priority date is current and you haven't filed within 1 year. There are a couple of questions, and if you all have other questions, keep them coming, and I'm happy to take a look. So have read on the news that USCIS suspended withdrawals proposed biometrics rule. So yes, that is related to the H4 and L2 biometrics for H4 and L2 extensions or changes of status. That became back in I think it was 2019. Anyway, during the Trump administration, USCIS required that it was a new requirement that anybody who's filing a change of status or extension of status for the H4 or L2, which are the dependent classifications of H1B and L1, that they would have to have the biometrics done, the fingerprinting done. So there was an additional fee, the $85 fee, and it took a whole lot more time. So it used to be that if a person filed, let's say the H1B in premium processing and the H4 as well, then as a courtesy, USCIS would also premium process the H4. H4s are not eligible for premium processing, but as a courtesy, they would do that. That stopped when the biometrics went into effect because they couldn't. They had to wait for the biometrics to be scheduled and then processed. And so it's taking forever. If you have filed an H4, you know this. The processing time is 10 to 13 months for an H4. And then, of course, the same for the H4 EAD if you apply for that as well. Anyway, what this person is referring to, the question about they've read that USCIS has suspended the biometrics rule. Yes, that's correct. And it's because a group sued USCIS. As of May 17th, which I think is Monday, biometrics are no longer required. USCIS has not given us instructions on how to handle that. They haven't officially said that the biometrics fee is not required. I can't imagine that it would be, but hopefully they'll tell us, before Monday, that the biometrics fee is not applicable, but that applies to the L2 and H4 EAD, or L2 and H4s, not to the green card process. Biometrics will always be required for the green card process for the I-485 filings. But as I said, if you've had them done before, USCIS is trying to reuse them, which is great because fingerprints don't change, obviously. If you work on new employer on EAD, I have back on previous employer who processed the green card while prior to date current. So I think this person is saying if you filed the I-485 with employer A, let's say the employer who filed your perm and your I-140, and then you get the EAD and then you change to employer B, then I think this person is asking, do you have to go back to employer A? And the answer to that is yes, you have to go back to employer A. It's a complicated answer. You have to go back to employer A when you get the green card, at least as of the time you get the green card, unless you could have ported, or unless you did port your I-485 to the new employer. So I talked about I-485 portability a minute ago. I said the I-140 has to be either approved or at least approvable. You have to have the same or similar employment, and the I-485 has to have been pending 180 days or more. So if that's the case, then you may be able to port to the new employer, but otherwise, yes, you would have to go back to the original employer, at least as of the date that you received the green card. This is a great question. Do priority dates apply when filing a family-based I-485? They do not apply. Priority dates do not apply. They're not a thing for for immediate relatives. Immediate relatives are spouses of US citizens, spouses and minor children of US citizens, and parents of US citizens. Everybody else, yes, priority dates are a thing. There's a visa bulletin, a family-based visa bulletin that's on the same page, website page as the, or webpage as the employment-based, and yes, priority dates are a thing. So for example, if you are a green card holder, a permanent resident, and you're filing for a spouse or for a child, then a priority date would apply. Absolutely. Or if you're a US citizen, parent filing for a child, priority dates are a thing, but they're not a thing for immediate relatives. So if you're if you're a foreign national married to a US citizen, priority dates and the visa bulletin are not a thing. Can I file I-485 through previous employer if the previous employer withdrew the I-140? If not possible, can it be filed with a new I-140 in regular or premium? So if an employer withdrew the I-140 petition, it depends. I think it's a not clear situation, because if the I-140 petition has been approved for more than 180 days, USCIS basically says to the employer, look, you can write to us and ask us to withdraw, but we're not going to do anything. It's still valid. It doesn't have any impact on the validity of the I-140 petition. But that it's not a clear cut case. So if you're in that situation, I would definitely have a consultation with us and come up with a clear plan, because it may be that you don't want to take that risk and you want to go ahead and file a new I-140 petition. Because the previous one had been withdrawn. Again, it's very fact specific. Biometrics rule, current outlook for people whose date is current in May visa bulletin are going to be current in June visa bulletin, and I-485 filed 6 months back. So in general, if your date is going to be current, or you think it's going to be current per the final action date, not per the dates for filing, but final action date, in May or June or whatever it is in the future, then if you see your date is current, let us know if we filed, and I know for this particular person, well, just in general, if we filed your I-485 application and you see the date is current, let us know. Or if you filed through another attorney, let that attorney know. Our practice is we place a service request with USCIS, we send a letter. If we don't hear anything, then we encourage the client to contact their congressional representative, because you want to try to get that case approved before the dates retrogress again. And we like to remind USCIS that the date is current. They're supposed to pull cases and keep on top of it, but we want to do everything we can to remind them that the date is current. So if you're one of our clients and you're in that situation, feel free to remind us. We also keep track of that, but feel free to remind us. We're happy to help you reach out to USCIS and just remind them, give them a friendly reminder that the date is current. does not mean it's specific to the H4, not I-45. I think this person is asking about the biometrics again, and yes, the resending the biometrics is specific to the H4, not to the I-45. There's always biometrics requirements for the I-45, but like I said, they try to reuse the biometrics if they can, if it's already been done. Would traveling to Canada for less than 30 days affect a pending advanced parole application? Yes, my understanding is, and experience is, if you leave the United States, and Canada's a different country, I know you know that, but some people, anyway, it's close. But anyway, if you go to Canada or any other country while the advanced parole application is pending, then yes, it would likely be denied. So if anyone else has questions, feel free to put them in the chat. Otherwise, I'm going to wrap this up. So we try to share information on a regular basis with our clients that we think is helpful for everyone. I know immigration is very confusing. It can be stressful. It can be anxiety producing. I've never been through it myself. Obviously, my ancestors were one of the first undocumented foreign nationals in the United States. But in Jamestown, but we feel for our clients. We know it can be really stressful. It's really confusing. The information I went over today is really complex. Like I said, it's level like 301 immigration law. So if you didn't quite catch everything, it's totally fine. It's not you, it's immigration law, and that's why we have jobs. That's why we're here. We're here to help you. So we're happy to share information. Ways to stay connected with us are to read our blog posts. We post on our website on a regular basis. We have an email newsletter that we send once a month, usually on the first Wednesday of every month, and then RSVP to future webinars. We hold webinars on different topics, or we have just an Ask the Attorney webinar, usually on the second Wednesday of every month. If you have suggestions for topics for future webinars, we would love to hear those. Just shoot us an email to info@sumnerimmigrationlaw.com. You can also contact us or stay up to date with us through social media. We're on Facebook, Instagram, LinkedIn, especially my personal LinkedIn page, Emily Sumner on LinkedIn. And we're also on YouTube. We're uploading videos to YouTube as well. So I hope that you will follow us on those sources and stay up to date with all the cutting edge changes that could affect you and your career and your families. Again, if you have questions, feel free to send us an email if you're a current client. If you're not, we would ask you to set a consultation so that we can make sure to get all of the relevant information and give you correct information. This is our contact information. I really appreciate you joining us, and I hope that you will join us again and tell your friends. Thank you so much.